I'm Jeannie Patterson. I'm the Director of the Centre for AI and Digital Ethics at the University of Melbourne. AI is everywhere at the moment, and there's a great deal of interest in how we regulate AI to make it safe, fair and responsible. In this series, we dive a bit deeper into some of the big issues of AI and AI policy and AI regulation. In this episode of CAIDE's AI Policy and Law Forum, we think about AI, intellectual property and the creative industries. We know that AI has tremendous capacity to create images, create text, create scientific outputs. But what about the training data? What about the rights of people who own the copyright in the training data? What about the outputs of the AI? Similarity, regurgitation. Who protects the interests of creative people in our society? In this episode, we think about some of those issues with experts in the field who thought carefully about the matter.
Everybody remembers the first time they got to use AI, whether it was ChatGPT or Microsoft Copilot or some other product. You all experienced that moment of typing in a prompt and getting a response back and marveling at the idea that this AI was creating words out of nowhere, giving you answers to questions. But quickly we started to realize that the AI was not always generating answers that were perhaps truthful, or in some cases the AI was regurgitating information that seemed like it was a copy of some other information. So what we have with AI today is two big challenges, one of which is hallucinations, where the AI is effectively making up facts without any reasoning behind them, or something called regurgitation, where the AI is actually repeating information that it has seen in its training data and seemingly reproducing what might be considered someone else's content or copyrighted content. We need to understand how this happens so we can understand how to think more clearly about the legal operations and ramifications of that. So when it comes to regurgitation, what we're actually seeing is a situation where the model has, in some way during its training process, learned a piece of information. Now, we might find that that information has been what we call overfitted, in that the model has learnt that information so many times that its training has geared it towards really understanding that to be the most optimal response. And so in a situation like that, overfitting, regurgitation might actually give back to you a complete copy of another piece of work or a piece of training data because you asked a very specific prompt that elicited that exact response. The other option we have is underfitting, where a model has not seen a lot of information in its training data about a given topic or subject, or perhaps a specific piece of written text. And therefore, because it's only seen a few instances of it, when prompted to repeat or at least acknowledge that information, the model has nowhere to go other than to repeat that same information back to you because it's the only source of information it has. So as we now understand that it's a combination of the things that we prompt models, but also the data that models are trained with in the first place that has an impact on how models reproduce content and issues like regurgitation can appear, we need to think about making sure that we build the right legislative, but also the right environment to make sure these models are open and available to us to create the outcomes and the creative exploration they offer, but also maintain the protections to copyrighted information as needed.
So one of the really profound challenges about understanding how intellectual property interacts with generative AI is scale. The kind of volume of inputs that we're talking about that have formed training data are really beyond comprehension for most people. A conservative estimate of the text for written training data is something like 3.7 billion pages of Microsoft Word, if it were ever expressed in that format. And that doesn't take into account all of the images that have formed part of that training data. So when people talk about works and individual pieces of copyright, they're sort of forming part of this morass of information in a format that is very difficult for lay people and copyright practitioners to understand. Building on top of that complexity is this idea about understanding the technology itself. So 2 years ago, nobody knew what a diffusion model was, and overnight we've all become big data analysts. It's a very complicated system to understand how it takes the training data, and then outputs it at the other end. Authors like Catherine Lee from Google at Cornell University have described it as a supply chain. There are 8 different intermediate steps that take place technically from the moment of taking data and then generating an output and fine-tuning the model. At each point in that life cycle or supply chain, as those authors have called it, there are different interactions with intellectual property law, different applications of reproduction rights in copyright law. It's a very complex problem.
What we now know is AI has the capability to exacerbate the presence of inauthentic art, but also the misappropriation and misuse of Indigenous cultural and intellectual property. What I mean by using that term, which is often also referred to as ICIP or ICIP, is the inherent right that First Nations people have to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expression. When ICIP is misused or misappropriated, this can lead to ICIP being used without First Nations peoples providing their free, prior, informed consent. It can mean that First Nations people aren't attributed in relation to the use of that ICIP, and it can also mean that benefits do not flow back to community, amongst other things. Through the misappropriation and misuse of ICIP, this can also lead to First Nations people infringing their cultural obligations. And in fact, we saw that in the Bullen case. In this case, it was found that First Nations people have a fiduciary duty to their clan groups. One of that is to ensure that they act in accordance with their customary law, but also to ensure that they protect the interests of community. There must be a shift in the narrative and language that we use around AI. This shift has to ensure that First Nations peoples are empowered to be part of AI development. It must ensure that First Nations people are self-determined in the use of data and information, and that's crucial in the recognition of ICIP rights, but also in recognising Indigenous data sovereignty.
The Productivity Commission recently put out 3 volumes on AI regulation and data. Short volumes, recommend you read them. What are our key messages though? Firstly, Australia has a productivity crisis. AI may be one of the solutions. It's a general purpose technology that's particularly valuable in service industries. It may help revolutionise the laggard areas of our economy. Those non-market services like health, education, aged care, disability, where we've seen no productivity growth for 20 years. What are the risks of AI? So AI represents a magnificent opportunity, but it's got a terrible name. If it had only been called computational statistics, no one would be getting worried about it at the moment. Instead, it's artificial intelligence, machines are coming. So there's always a risk of regulating too early and too much. What are we seeing in some overseas jurisdictions like the EU? We're seeing AI acts which are trying to limit the development of artificial intelligence tools before we actually know what the risks and problems are. A better way, we suggest, is to look at the tools, look at the risks, work out if those risks are covered by existing laws, and most of them will be. Work with the regulators and industry to help that coverage. And then, if there are gaps, come up with new technologically neutral rules, because you can be guaranteed the rules that we write for today's ChatGPT-4 will be obsolete in 10 or 20 years. Data is the fuel of AI. It's a wonderful fuel because multiple people can use the same data set at the same time without reducing each other's benefits from that data. It's completely different to any other fuel. It's not like a barrel of oil. So data is an amazing resource. But legally, we have holes all the way across our data rules. We have at least 3 different areas of law coinciding: intellectual property and copyright, privacy, and the rules relating to data revelation, like our compulsory consumer reporting on credit. How do we put the different and competing approaches to data together to create a coherent system that allows AI to develop whilst protecting individual rights, individual privacy, and creating trust in the system. That is the huge challenge that we all face when thinking about AI over the next decade.